So what was the ruling in Texas regarding adults under the age of 21 carrying handguns outside the home? On August 26, 2022, Judge Mark Pittman for the Northern District of Texas, federal court there, ruled that Texas's statutory scheme that prohibited adults under the age of 21, that's folks who are between 18 and 20, that statutory scheme prohibiting them from carrying handguns outside the home was unconstitutional. Now, what does that mean? The judge ruled that not only folks who want to constitutionally carry between 18 and 20, but also folks who want to go get a concealed handgun license between the age of 18 and 20, that scheme is now unconstitutional due to the Supreme Court's ruling in the Bruen case earlier this year. So what does this ruling mean for handgun owners under the age of 21 in Texas? So first off, let's discuss what it does not mean. So the judge did not rule that all folks under the age of 21 can now carry a handgun outside the home. People who are prohibited persons, i.e. felons, or if you were admitted to a mental institution, prohibited persons are still prohibited from carrying firearms regardless of their age. In addition, location restrictions still apply, and the judge specifically ruled that based upon the ruling in the Bruen case. So just because you're 18 to 20 and now think you can go outside and carry a handgun, there's still a whole slew of prohibited places where you cannot carry. Finally, the most important part of what the judge did is he issued a stay of this order, which means the order will not go in effect for 30 days, or if there is an appeal of the order, the stay will continue throughout the course of that appeal. So that means right now, if you're between 18 and 20 and you go carry a handgun outside the home, you can be arrested, you can be prosecuted, you can even be thrown in jail while this case is proceeding through its appeal. So please do not go outside with your handgun until we have a final resolution of this issue. So how does this ruling impact handgun owners under the age of 21 right now, and how might it impact those folks in the future? So right now, given that there is a stay of this order, it means that if you're under 21 and want to carry a handgun outside the home, that you can still be prosecuted, thrown in jail, charged with the crime, all of that. So do not do that if you're under the age of 21. There are some folks who might say, okay, we have a court who ruled it's unconstitutional. I'm willing to take that risk. Okay, you can take that risk, but you can still be arrested, charged, thrown in jail, and then some years down the road, we might have a resolution of this issue at either the Fifth Circuit or the Supreme Court, at which point you'll be, quote, vindicated, but will have spent time in jail and spent money on attorney's fees and countless hours in the legal process. If this case is upheld on appeal, which will be in a year, 2 years, maybe even longer if it goes all the way to the U.S. Supreme Court, at that point, if you are under the age of 21 and want to carry a handgun outside the home, you may apply for and get a permit to carry under this court's ruling. Now, what will happen is Texas will have to modify its permitting scheme to address those issues. And then number two is if you wish to constitutionally carry and meet all of the additional requirements there, you will be able to constitutionally carry outside the home as well. So could we see any more or different age regulations or restrictions here in Texas? Probably not. Right now, the Texas legislature has been very pro-firearm, so it's not likely to impose any new restrictive rulings. Even if it wanted to, or if other states wanted to, what this court ruled was that under the new Bruen case from the U.S. Supreme Court, courts have to look back at historical rules and laws and compare this new law, the modern law, to what existed at around the time of the passing of the Constitution and at the time of the 14th Amendment. And so if there's an age restriction now, you look back and say, well, were there age restrictions back historically that the founders could be thinking about when they passed the Constitution? And if there were not, then this new law will likely be unconstitutional. That's what Judge Pittman did here in Texas, and he found that there were no age restrictions back around the time of the Constitution, and so this new law, or modern law, is unconstitutional. So does this ruling impact folks under the age of 21 who may already have a concealed carry permit in Texas? No, it does not. There is a limited group of people who are able to get a permit under the age of 21. It's very limited. Most folks cannot. But this ruling should not impact them in any way. If they already have a permit, they're great. If they don't, there is a stay in place that will still allow the police to go out and charge you and arrest you for unlawful carry if you're under 21 and do not have a permit. So will this ruling have an effect on any other states? It is technically not binding. What we call in the legal parlances, this is not going to be binding on any other states or frankly any other district courts here in Texas. Now what it is an opinion that other cases and other states can rely on. So another court could look at this opinion and say, yep, I believe that ruling is good. I'm going to go along with them. But it does not bind any other courts in any other states at this point. If it were to be affirmed by the Fifth Circuit, it would then be binding on all of the federal courts in the Fifth Circuit. And if it were to be affirmed by the U.S. Supreme Court, it would then be binding as to all the states.